Good morning and welcome to another episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, attorney at law, and I'm glad once again to bring the law and you. Today we have a very good topic talking about your neighbor. Is your neighbor disturbing you? Is that business enterprise causing you great discomfort? What about nuisance? Of course, this is the Nuisance Understanding Nuisance program. Today, my guest in studio is Rondell. He said he's a version 2.0 with an E. His name is Mr. Rondell Keller, attorney at law, young attorney. And just a little bit about Mr. Keller. He has been recently, not recently, but he's admitted to practice in Trinidad and Tobago and Guyana. He grew up in Maloney, where he's a proud graduate of the Bonaire Government Primary School and El Dorado Secondary Comprehensive School. In 2011, Mr. Keller attended the University of the West Indies St. Augustine campus, where he graduated with a BSc International Relations, attaining first-class honors. Mr. Keller also attended the Central China North University in Wuhan, dangerous name, China, in where he developed his language proficiency in Mandarin Chinese. Thereafter, Mr. Keller completed his LLB, graduating with first-class honors again and valedictorian of his class. Mr. Keller then went to the Hugh Wooding Law School, where he graduated at the top of his class with a Legal Education Certificate of Merit, with other awards for civil practice and procedure and the law of remedies. Mr. Keller also recently attained his LLM Masters with distinction. Mr. Keller is also a university tutor at University of the West Indies for the past 4 years, where he tutors the law of tort, and his main areas of practice is public and civil litigation in Trinidad and Tobago and Guyana. Apart from law, he's a member of the Heliconia Foundation for Young Professionals and has a passion for aviation, politics, youth activism, and Trimbago culture. Very impressive young man, and I'm happy for him to be in studio. Good morning, Mr. Keller.
Good morning, Rondell.
And how are you, Rondell?
I am fine. I'm glad to be on the set.
Good. Happy to have you.
Me.
Yes, happy to have you. So let's get right into the discussion. We are speaking about disturbing your neighbor, understanding nuisance.
Yes.
Now, in this current economic climate, of course, we have both persons that are living close to businesses, as well as persons who are being disturbed by their neighbors.
Yes.
Now, tell us, what is nuisance, or what is private nuisance?
Well, nuisance on the whole, we have two types. You have private nuisance and public nuisance. Private nuisance really deals with one neighbor, probably an adjacent property, using his land in a way that is probably unreasonable in these circumstances, and it interferes with your enjoyment of your land. And that is the cause of action there for private nuisance. But then on the other hand, we have public nuisance. It's actually a crime under the Summary Offences Act. And a public nuisance disturbs the population at large, the public at large. However, it could generate a claim as a private individual or personally to bring a claim where that disturbance, that's a public disturbance, is above the degree and disturbs you more than the average person in Trinidad and Tobago.
And when we say, I know that we would have distinguished between public and private nuisance, but today, what are the rights of a person or of a neighbor in that context if they want to bring a claim for private nuisance?
Well, first off, to bring a claim in private nuisance, you must have a possessory interest in that land. So you must have either you're a tenant there, you actually own the land itself. You can't just be someone who merely visits, let's say, your grandmother, that property, and you're disturbed. You must have an interest in that property first and foremost to bring an action in nuisance.
And when you say an interest, does it mean that you have to be the owner of the property, or you can be a tenant, you can be a licensee, etc.?
Certainly, a tenant, licensee, someone with a possessory interest. So you have that exclusive possession, those rights that you get as a tenant. A part of being a tenant is that exclusive possession element in it. So you are in control of this property, you are there, you are the person who is entitled to the benefits and the enjoyment of this land. So then now when you have a neighbor on the other side, disturbing it, or anybody in the vicinity disturbing it, you having that interest can raise your claim in court and say, well, I want this stopped.
And what about persons, let's say, living in an apartment setting? What sort of possessory title do they have? Is it a matter of nuisance in their apartment or in the compound?
Well, it will be each apartment, depending on it, if it's like a condo style, each apartment will have their own interest in there. So you have apartment A and you have apartment B. There's two separate interests there. And you could bring a claim in nuisance against, let's say, if A is the nuisance maker, then B can bring an action against A as tenants in that same building. But sometimes you may have a management company in those condo-style apartments where you might be able to get some remedies within. Not everything is about litigation. Sometimes you could come up with a practical solution, maybe mediate that situation out using your management company in that apartment complex.
And tell us, what are some of the examples of a nuisance by the offending party? I know there's a lot.
It could go on and on, but noise is the main one. So persons playing music, maybe they have a mechanic shop next door and they're making a lot of noise. You can have smell, for instance. So again, if a shop is next door, maybe the paint fumes is affecting you. That could also be a nuisance. Encroachment onto your property. Maybe your neighbor sapodilla tree is growing over into your yard. That also in itself is a nuisance.
Okay, so let's discuss on the noise aspect.
Yeah.
Now, of course, we know noise can emanate from, as you said, a business enterprise, as well as someone private. So therefore, if a neighbor's dog is making noise, constant barking. Of course, you know, dogs in their habitat, they bark.
Yes.
That's what they know. That's their instinct.
Yeah.
How do you treat with that particular instance where animals are now becoming a nuisance?
Well, it will all depend on the degree. So we must first make sure it's an interference. So noise could be an interference, but it must be unreasonable. Having a pet, I think, maybe just one, is something you expect to be something reasonable in a particular neighborhood. But what the court will look at in determining whether it's unreasonable is the locality as well. So let's say, perhaps let's say hypothetical speaking, we have a plan, this area where it is meant to be quiet, totally quiet. Maybe
a residential area.
Exactly, a residential area, maybe with particular stipulations and conditions that it must be extra quiet in terms of pets, etc. Then you might be able to say, based on the locality of where I am, then this dog is being unreasonable. But I won't say maybe having one pet, one little pit bull or some little humpback always barking would be enough to say, well, this is in fact a nuisance. But the degree, let's say we have 10 dogs in this yard and it's going on and on and on and on, well then I think you may have action.
And of course, with as these 10 dogs, if it now involves unsanitary conditions,
yes,
this is where the public health departments of the corporations also can come in.
Exactly. And I mean, even the smell from it as well could be a nuisance to you. So your neighbor's yard is filthy, and that smell emanating from the yard from the lack of sanitation, that in itself could be a nuisance of which you could bring an action in itself.
And as we're on the discussion of noise again, I know there was a recent judgment with respect to a promotion company, I think it's Wild Goose, and against the EMA as well as the inspector of superintendent of police. In that judgment, can you explain to the average citizen what exactly was that case about?
Well, that case touched on concern, I believe it was the tailgate theft that occurred sometime, I think, in 2019. And the police, coming down to the end of that theft, shut it down essentially. And they brought a judicial review action, and I think you had a guest speaking about judicial review and doing that. So they brought an action to review that decision as being irrational, illegal, etc., going ultra-vires the powers of the police as provided under the Environmental Management Act. But that decision had a great impact on the power of the police to shut down thefts. And I know some of the Woodbrook residents might be very concerned about the power and the limitation that this judgment has now put on police in terms of shutting down thefts, because the High Court, determined that that power does not exist even when a noise variation is given.
Because as well as reading the judgment, I would have seen that there are certain protocols that has to be followed according to the Noise Pollution Control Act. Sorry, not Act, regulations. Whereby you can't just shut down a theft. There are certain things within the rules that you have to follow in terms of there must be a letter being sent, a notice of that violation,
giving them that reasonable opportunity to fix the issue that they are having. That principle is in keeping with natural justice itself. You must give somebody a reasonable opportunity to do something and put them on notice that they're actually in violation of that thing. So in the tailgate, in the Wild Goose decision, we see the details of the facts, which I think sometimes it could be quite comical, reading the facts of that case. But even though they showed him allegedly the readings going above the noise variation limit, they still needed to follow what the Act prescribed because they are a statutory body acting within that limits and they can't go beyond it. They tried to argue it was an emergency and necessary, but that didn't work.
Because there's no procedure in terms of an emergency, or rather they didn't satisfy the threshold of what an emergency
Correct. They
is.
needed to prove that is an imminent harm to life or the economic interests of Trinidad and Tobago. They weren't able to pass that threshold to say it was an emergency. And further, the Act says that they must consult with the minister first before taking any steps to say it's an emergency. So I think that decision is, it however renders the EMA a little one to go on again for the EMA. So maybe we will have to review how the noise pollution control rules are done and what are the procedures for persons going beyond their noise variations.
And of course, I would have the EMA at my next program dealing with that particular issue and how they can render some sort of regulatory advice or something like that. Now, with respect to a FET, let's say, for instance, a resident has had that discomfort based on that FET or party or whatever. Can they now bring an action thereafter for that nuisance or for that noise pollution?
Well, it will depend on if it is the duration factor will have to come into account. So again, you must have an interest in the land. You say the neighbor has that interest. It must be interference. We say the interference is the noise. But the noise must then be unreasonable. And again, a factor apart from locality, maybe this area might be considered, the Woodbrook area might be considered a FET area because the locality is changing, the nature of it has changed. But then we'll also consider duration. And if it's one FET, maybe a few hours, keeping in mind what the kind of remedies are for private nuisance would be an injunction. You can't really get an injunction for something that's already gone. And then damages. But then you'll have to prove that this nuisance, this noise that's emanating from this FET went to such a degree that it caused injury to your property or person. But if it's fleeting, temporary, the action might not be in private nuisance per se. But you could report it to the police. The Wild Goose decision actually kind of identified that the police need to act on complaints when they're going pursuant to the Summary Offences Act to say that it's a public nuisance. And you must show that in the locality there's a sufficient degree of persons complaining about the nuisance itself.
Understood. And let's now move to another cause. For instance, there are persons who are living next to construction sites or even garages. And what are the complaints that there are vehicles parking in front of their driveway, moving in and out, causing harm to residents' property? What sort of can that be considered a claim for nuisance based on that sort of discomfort?
Yeah, it sounds like a mixture to me of the private and the public, because on the roadway itself, your neighbor won't have an interest per se owning that roadway. But if that roadway is now going to a degree of blocking your right of access to your property, that in itself gives cause of action for that public nuisance element of it. But the private part of it, in terms of the noise emanating from the construction work on your neighbor's side, that could be as well. But we have to always go back to the factor, is it unreasonable? Because at the end of the day, your neighbor also has rights. So we have to balance the competing interests here. Because I want to use my land as I want to. You want to use your land as you want to and be in quiet. However you want to treat your palace.
Yeah, because a lot of times, especially when persons building their property, there are always issues with one neighbor saying that you are encroaching on my property, you are building too close to my property, you are excavating, and then that leads to now persons having to file action or what you call an injunction, and I'm sure you'll explain in terms of how the procedure for that is.
Yeah.
So where do we find the middle ground?
Well, if it goes, one thing with nuisance for sure, your action is secure, sound when it results in physical damage. So if we see someone with their their noise or their construction, maybe they're pile driving these rods into the ground and it's causing damage to your property itself, well then you're well on your way to claiming nuisance. Physical damage is probably the best way to show that it's unreasonable. But in terms of construction, we also have to remember that we live in a society where we are progressing day by day. And construction is an element of that. So sometimes I know you really want to have that peace. You don't want to hear the neighbor who is shoveling and mixing cement early in the morning.
Or even I know there was someone that stated that the waka man.
The waka man, yes.
At 4 o'clock in the morning.
No, I once, there's a resident group that I have, and there was someone who posted in the group chat, could you please tell persons that maybe 9 o'clock on a Saturday is the best time to cut grass? But I know everybody always has this, what time is the best thing to start cutting grass? But interestingly, the noise pollution control rules provide that you can start cutting grass from 7 o'clock in the morning, and that wouldn't really be in violation of the noise pollution control rules. But that apart, we have a situation where maybe you could show that your neighbor always cutting grass. Maybe there's this neighbor who is obsessed with the lawn that he has. And
every morning between 5:30 and 6.
Or maybe even 7 o'clock itself, when we add it up every morning, Monday to Sunday, you cutting grass. Well, then maybe you could start saying, well, this is unreasonable in circumstances. Looking at the locality, this is a residential neighborhood. Birds just be chirping in the morning. I like to drink my coffee in peace. But all I hear is every morning. Well, then you could start the process. And I would also recommend to my clients to document. Sometimes taking a little journal of how things go down. It helps your attorney as well in putting together your claim and preparing that affidavit for the injunction. When you could document, maybe you made a report, have your documents and your records in order for us.
Now let's say you are living in a district, a commercial district. Now we have the private residence, we have the commercial district aspect.
Yeah.
And of course, that's an industrial area, so there are a lot of noise that will have been taking place, etc. And a resident now wants to bring an action against a company for constant noise in that district. Can they succeed based on the fact that the locality where they're living?
It will be a difficult one. They'll have to prove that it went above and beyond what is expected in an area like that. Sometimes persons at times will try to raise the defense that you came to the nuisance. You know that this area is an industrial area and you still came here. But that in and of itself is not a defense. We'll always have to go back to the main criteria of unreasonableness. And it really is a question of fact more than law. The court will have to sit and, look at the times, look at the area it is, compare it to another area, looking at the history of the area and how it has evolved moving forward.
And unreasonableness could be my definition of unreasonableness.
Exactly.
Could be different from your definition.
Exactly. So the court actually will look at your sensitivity and say, well, maybe your taste or your sense is a little too high for this area. And perhaps it is not unreasonable having regard to the fact, so let's say Makoya, for instance, we know that area is an industrial area. You have the Omera area as well as an industrial area. You putting your house there, have to understand that there is that risk of understanding that locality, there's the inherent danger of you living in that society, that there are these regular nuisances, I guess.
And again, there are a lot of neighbor disputes whereby a neighbor will just start to swear at you constantly, as you say in local parlance, cussing and carrying on for no reason as they come home in the middle of the night. It's just cuss after cuss. And a lot of times person go to the police.
Yeah.
Now, what are the police ought to do in that circumstance?
Well, they should go and investigate. I mean, when someone makes a report, the police has a duty to investigate it. Sometimes it doesn't always go to plan.
Indeed.
It doesn't always go to plan. But that could amount to a public nuisance depending on how the degree of it and also a disturbance of the peace, which the police has the power to arrest persons in those circumstances. But you're in your private home, and again, we have to understand you have a constitutional right to your private space.
But a lot of time you find that the police is saying that this is a private residence, this is private, so they can't get involved And then you wonder what is their remit? Because if you are disturbing the peace in your private dwelling, to me now that becomes a public action.
Yeah. But to me also, Rondell, it sounds like we crossing into the realm of domestic violence and needing a protection order, but
against a neighbor.
Well, I mean, it depends if the violence is happening that way. But but in terms of your neighbors, again, not everything is court as well. Not everything is wanted to litigate something like that. And they might consider that to be frivolous in these circumstances. But I would still say make the report. You might also be protecting someone's life or interests in that regard. But I won't say it's something that you should readily want to run to court for, because litigation is expensive in itself. For your neighbor cussing. While you might get your costs back, there's no real damages you may get from that. And how do you really enforce an injunction on two neighbors who can't stand each other and they're always cussing? So you always have to be running back to court to say, hey, look, they violated the injunction because they're cussing each other.
And this is real life scenario, you know. No, let's Rondell. It's so weird saying Rondell. But
the 2.0.
At 2.0, according to you.
Everything that was lacking, they improved here, except Calypso.
Let us focus on what we are here about. So what are the steps in bringing an action for nuisance? Start from the beginning, direct to litigation.
Well, okay, let's use noise, for instance, or smell. These are the two nuisances. Let's say we have a mechanic shop next door, and the noise and smell is too much for you. Apart from, so you will be documenting how long this has been going on. I've seen persons in certain circumstances use professional companies to actually measure the noise levels, so they have that readout as proof to support their claim. But we will start most times with an injunction, some interim relief, because your claim is an arguable case, you have an arguable case to go forward with nuisance. So starting with an injunction, we do that for interim relief, but it must be followed up right after with your claim. So you file your claim form, your statement of case for your full particulars of your nuisance. And the action starts there. And the litigation process rolls forward. You have the defense coming in, and we may move to a full trial, or you may have your neighbor at the, what we call the case management stage, making some consent orders or undertakings not to conduct the activity during particular hours.
Now for persons who, because of course the lay persons are listening to this, viewing this program, what is an injunction?
Well,
Let's explain the injunction aspect.
So the traditional sense of the word injunction is to prevent someone from something, but you could prohibit someone from doing something or mandate someone, make someone do something with an injunction. Most times the type of injunction you will get with claim for nuisance will be the prohibitory injunction, stopping your neighbor from doing something. Perhaps most times the court won't stop you absolutely, but they may put a time limit. So they may say this mechanic shop could only operate between the hours of 9 a.m. and 3 p.m., Monday to Friday, for instance. And that will be the injunction itself. So if the neighbor goes beyond 3 p.m., then he's in violation of that injunction, which prohibits or stops him from doing that mechanic work during those hours.
And are you saying that that with the injunction, does a pre-action protocol letter still have to be sent to that neighbor?
Ideally,
knowing the urgency?
Well, in some cases, I have, where you're also trying to keep in mind your client's pocket. Litigation itself, you don't want them to just unnecessarily run into it. And it also is good to show the court that you tried yourself to mediate the situation beforehand, because we have this overriding objective to try to settle matters out of court before actually reaching to court. So in a circumstance like that, you won't give them a 7 days or 14 days to respond. You'll serve them with that letter as personally as possible.
And you will also file your injunction sometimes Sometimes
you file. So I say the client comes in at 9 o'clock in the morning. We say you have until 4 p.m. to respond to us on these claims. And if by 4 p.m. you have nothing, well, then we move forward. But it will all depend again on the urgency, the emergency, if there's probably damage being caused to your property from the paint, fumes itself, probably is damaging your wall, or maybe someone is excavating, or water is running from their property onto yours. It will depend on the degree itself. But not all cases, it's not a broad brush approach to say, I will send a letter before. Sometimes you just have to run to court.
Yeah, and of course you file your injunction. And what sort of reliefs are there? Because I know, of course, sometimes you get interim reliefs. So you would explain.
Well, the injunction before the claim itself, or sometimes you can file both of them at the same time, but you must have a claim following up. The court, for this type of action, will generally only give that injunction in terms of the time limit when you can operate it. Given the fact that the remedy itself for nuisance is really just an injunction or damages flowing from that. So the injunction will just simply be interim pending the full trial of this nuisance claim. And it can happen so if you file your claim, your injunction application, let's say sometimes 4 p.m., you file it with a certificate of urgency, so to tell the court, I really want this. I have had instances where the court would have responded maybe 6 p.m. and say, okay, we'll hear you at midnight. And it's quite interesting how quick the wheels of justice could turn in an instance like that, and you can get your injunction and some relief, some reprieve in the interim pending the full trial of your claim. And
what mode of communication are the court? I mean, of course, we are in now the pandemic and everything is virtual. When an injunction is being heard at midnight, what mode is that injunction being heard?
Well, sometimes, once I had a call on my cell phone, and you could have a teleconference sometimes between the parties, but you may have that injunction being heard ex parte, which means that we're not going to hear the other side at all. The judge is just going to listen to you and your attorney, plead your case, give you that interim relief in the interim.
Because they see it as urgent.
See it as urgent, and then say, please serve this application on the other side and come back in maybe 7 days. Let me hear if I should even keep this interim order going. Because maybe the other side might come and say, well, I don't even paint. I don't even do these things that this person is saying. It's just really just my dog barking, and they're exaggerating the claim. And the court may say, well, let's discharge this order. I prefer to give my final injunction or whatever orders at the actual end of the litigation itself.
And what are the consequences? Let's say, for instance, someone succeeds after the injunction. You have the claim, the substantive claim. What is that procedure, and what is the reliefs in that substantive claim or damages?
You won't get damages in the interim most times. Unless there's probably personal injuries involving somewhere and you need that interim relief, some interim payment. But the claim form and statement of case, the relief you're seeking, most times would mirror the relief you sought in your notice of application, but for damages. You'll also claim your legal costs as well, because this person put you in the expense of having to go to court. So you have to get your costs back. After you retain your lawyers and you're successful. That's the principle in Trinidad. Winner gets his costs if you're reasonable. But it will be almost the same particulars being pleaded in your statement of case that you had in your injunction, generally.
And how does the court award damages for nuisance?
Well, it will depend on what was damaged. So if it was your property, most times they will compensate you for the repair of that property. If it was your personal injuries, there is a way that we go about general damages by looking at comparable cases. Let's say the smell made you nauseous. We look at what the court has awarded in the past to persons who were made nauseous by maybe some other substance or something like that. And damages, general damages would be awarded. Your special damages could be awarded as well.
And then also, what about persons who are ill, the elderly? If you're living next to a nursing home.
Exactly. Or maybe loss of business because of maybe the nursing home is losing clients because of the noise and the smell. You could also prove that to try to be compensated based on, because there's a cause and effect. You did this, and you caused me to lose these things, so you must now compensate me. So the court will try as best as possible to restore you back to that position that you had the nuisance not occurred in the first place.
And what about mediation?
As I was saying before, the practice directions as well as the overriding objective asks us as best as possible to consider alternative dispute resolution mechanisms. So it might be a case where you reach out to the other side and they probably have no interest in going to court. And you can have an all-parties conference, or we could have a third person come in. I say Rondell come in. Let's you being the objective person, listen to both sides, and come to a mediated response. And most times you'll want to put that in writing and have parties sign it. So you have this binding agreement between the two sides.
Yes.
I forego my right to sue you, and you are giving me this undertaking to do these things. And we can have a kumbaya over the nuisance.
Indeed. Rondell, your closing remarks. I know we are out of time in terms of...
Well, I want to say thank you very much for the opportunity. I know we have distinguished guests that sat in this very chair, and I appreciate the opportunity to be here. It was a pleasure, and I do hope persons who do have their claims, they document their claims well and seek your legal remedies if you're entitled to.
Rondell, thank you very much. You have been a brilliant guest, and of course, I'm sure your colleagues as well will be informed, as well as the general public. So thank you once again for being on Strictly Legal.
Thank you for the opportunity, Rondell.
So guys, it's a wrap, and I want to thank Rondell Keller, attorney at law, for being my guest on this topic, disturbing your neighbor, understanding nuisance. You have been watching Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa. Do have a great day. God bless.